Going to call on Government Orders of the Day, numbers 2 and 3.
Corrections Amendment Bill, Committee Stage. Privacy Information Sharing Bill, Committee Stage.
Honourable Members, I declare the House in committee for consideration of the Corrections Amendment Bill and the Privacy Information Sharing Bill. Mr Chairman.
Mr Speaker. The House and Committee on the Corrections Amendment Bill and the Privacy Information Sharing Bill. Members, we come first to the Corrections Amendment Bill, and the question is that Part 1 stand part. Charles Chevelle.
Thank you, Mr Chairman. Mr Chairman, I'm keen to ask the Minister and the Chair some questions about the effect of one particular section in one particular clause in Part 1, and that is Clause 5, because it is the principal reason for the Labour opposition's objection to this legislation. Clause 5 would permit the delegation of powers from the Chief Executive of the Department of Corrections to private sector employees, and as far as I'm aware, this scheme of private prison administration is the first example in our laws where powers of a public service chief executive are proposed to be delegated to a person not employed by the public service. I'd like the Minister to tell the committee whether or not the full ramifications of this issue have been considered, because of course when delegations of power are made from the public sector to the private sector, all the safeguards that have been carefully worked up to apply in the public sector no longer automatically apply. For example, can the Minister tell the committee whether or not the Public Service Code of Conduct will apply to employees in the private sector to whom public powers are delegated? If not, why not? Will the Corrections Code of Conduct, the Department of Corrections internal disciplinary and professional standards procedures apply to such employees when exercising powers delegated from the Chief Executive of the Department of the Department of Corrections? If not, why not? And then will all the statutory safeguards that apply in the public sector apply to such employees? I'm aware that in general terms, many of the wider safeguards are imported by earlier amendments to the corrections legislation as far as the running of private sector prisons are concerned. But when these particular powers are delegated, will, for example, the New Zealand Bill of Rights Act apply to the actions of employees in the private sector when they are exercising public functions, the functions that have hitherto been confined to the public sector? These are very important questions. The fact that they have to be asked in this way indicates, I think, that there hasn't been a full thinking through of the desire on the part of the government to delegate powers out of the public sector and across to the private sector. What are the ramifications in full of that decision, and what will exactly the committee and the House be agreeing to if this proposal is passed? So that's just one of the concerns that the Labour opposition has about this legislation, the ill-thought-through proposal that powers should be delegated out of the public sector and into the private sector without all the controls, professional and otherwise, that do exist and do apply in the public sector environment. And I think the committee could use quite usefully an explanation of what is intended and what the entire legal regime that will apply to such powers will be if this legislation passes. Of course, the question of whether or not the regime is ill thought through or otherwise is not the only problem here. We have a fundamental opposition to the idea of inmates being incarcerated by entities that are run for profit. And this bill will, of course, advance that agenda for ideological reasons and presumably also only for cost-saving reasons, whereas what we ought to be doing by way of a priority in our corrections system is absolutely focusing on the need to reduce reoffending, to get our prison numbers down, to get our number of offenders down, and to stop them from going through the revolving door that our prison system has been for as long as I can remember. And, Sarah, I can't see anything in Clause 5 that will advance that cause in any way, and I do hope the Minister will take some advice and get to her feet to discuss these points. Sir, the other concerns that I have about Part 1 of the legislation were ones that I spoke to in the second reading speech that I gave yesterday. And Clause 26, relating to strip search, is another of those concerns. We heard evidence in the Select Committee that the proposal contained in Clause 26 to standardise the manner in which strip searches are conducted to a very intrusive means of strip searching is going to cause a number of operational problems. And I would like the Minister to indicate to the committee whether she's actually turned her mind to these potential problems and whether she thinks there are solutions that can be had to them. The problems include the fact that Mr Chairman.
Charles Chevelle.
Thank you, sir. That the proposed standard procedure is a much more intrusive one than one of the procedures that can be applied at the moment. At the moment, if it's proposed to strip search a prisoner, then there are two types of searches that can occur. One is a relatively routine one that's generally applied if somebody, for example, has been out on work release. The other is when there is reasonable cause to suspect that the prisoner is concealing, for example, contraband. That much more intrusive procedure involving, as Clause 26.3 says, any instrument or device designed to illuminate or magnify the mouth, nose, ears and anal and genital areas will become the standard procedure to be applied in all strip searching situations. Now, the Select Committee heard evidence from the Corrections Association, the professional body and union of most prison officers in New Zealand, that this would lead to disorder, it would be provocative, it would be unduly invasive, and that it would not only lead to prisoners who are subjected to the more intrusive procedure as an automatic consequence of any proposal to strip search them acting up, but it would pose a risk to our corrections officers themselves. And that just doesn't even begin to touch on the issues of dignity and privacy that making this particular procedure a standard one starts to invoke. So, Sarah, I do hope that the committee will hear from the Minister about why it is that this particular proposal has come forward in the bill. The evidence as to its need is questionable. We heard from Mr Goff in the second reading stages yesterday about the fact that there's been a big decline, for example, in drug use detected in our prisons. And I've been able to confirm that when I've been to a prison, most of them are uniformly reporting that when they are undertaking drug testing, the level of drug use appears to be diminishing quite drastically, and that's because of the very good security arrangements that have been progressively put in place in our corrections institutions. People will have seen the work that was done by the previous government to make as a matter of standard security the fact that every prison is now enclosed by a high wire, and other secure measures are taken to ensure that prisons are drug-free, by and large. I'm not saying that there shouldn't be constant vigilance as to these matters, but what I am saying is that we do need to have a proper explanation in these committee stages as to why it is proposed to have this more intrusive procedure made standard, particularly in the face of evidence from the association the Professional Association of Officers at the coalface that actually it wouldn't make anything safer and would likely result in a less safe workplace for their members. And so that wasn't the only evidence in the committee that was heard that was critical of the proposal that's contained in the clause. The Office of the Ombudsman was critical of it. The Ombudsman obviously is the body under our international obligations that is charged with ensuring that prison complaints by inmates are properly investigated. It's the complaints mechanism for our international obligations concerning the need to protect people from torture and unfair conduct. So when they express a concern, we should be, I think, on our guard, sir. The New Zealand Law Society and the Salvation Army also joined with the Office of the Ombudsman in being highly critical of this clause. So, sir, I do hope that we will hear from the Minister on this, and also on the proposal that I spoke to earlier, sir, to delegate powers out of the public sector and into the private sector without, I think, a properly and carefully thought through consideration of what the consequences of those proposed delegations are, given that in private sector employment none of the safeguards automatically apply that do in the public sector.
Mr. Chairman.
Honourable Phil Goff.